Welcome to The Law Matters. Of course it does. Hi, I'm T.Morais, your host and moderator. This program has been created to educate, inform, and help you with the law matters just because the law matters. Understand the law better, understand the law, and you'll be in a better position to help yourself, your family, and your business. We provide information and resources that'll help you decide whether or not you might need to hire a lawyer. Perhaps we'll help you determine that in some cases you might be able to handle some issues yourself. If you do decide to contact outside counsel, you'll be better prepared, and as a result, so will the outside professionals that you connect with. Either way, you'll save time, money, and hopefully achieve better results. The Bazar and Associates law firm in East Providence continue to donate their time, energy, insights on the various topics that we cover, and once again, we want to welcome David Bazar, and at the same time, welcome Sam Bazar.
Thanks for having me here today.
Happy to. So, the topic today, landlords and tenants, their rights and responsibilities, from leases to evictions. How do you do it? Can you do some things yourself? Of course, the laws exist to protect both, and they do differ from state to state. So we're going to cover some of those legal issues that are designed to protect both of you, and also handle some of the frequently asked questions that are posed to us. So let's get started. Let's start with leases. There are leases and there are tenant agreements and rental agreements. So tell us a little bit about them, who needs them and why.
Everybody should have a lease because it spells out your rights. In a landlord-tenant situation, it's the rental amount, the period of time that the apartment or house or whatever is being rented to you, the residence is going to be rented for, whether you're allowed to have pets or no pets, what the security deposit is, and other rules and regulations that the landlord may have. That protects both the tenant and the landlord. It protects the tenant because it sets the rent in place, and it protects the landlord because if there are certain rules that the tenant doesn't follow, it may be grounds for an eviction other than for non-payment of rent.
What about if you don't have a lease, but it's someone who's likely to rent, I think they call it month to month. Do you need some documents to help or protect both sides in that case too, or no?
You don't need the documents. If you don't have a lease, the provisions of the Rhode Island Landlord-Tenant Act are the law that controls the rights and responsibilities of the tenant and the landlord. However, we always recommend having the agreement reduced to writing, so both parties understand what their rights and responsibilities are and can refer to the writing if there's any questions that come up in the relationship between the landlord and the tenant.
Do you have a sense of the advantages to the tenant or the landlord having a lease versus doing month to month? Can you jack up the rent if you don't have a lease? Does that make it easier for you to do that? Is it easier to evict someone if they're month to month? What's the story about that?
Well, a lease can be for a year term or it can be for month to month. The provisions of the Rhode Island Landlord-Tenant Act are fairly favorable to the tenants, and there are some things that can be changed in the lease between the landlord and the tenant, but the Rhode Island Landlord-Tenant Act also specifies that there are certain terms that cannot be altered by a lease between the landlord and tenant, and it's always good to consult an attorney as to what terms you can alter and what terms you can't alter.
So in a lease, as Sam says, it could be for whatever period of time you want to specify. The month-to-month tenant is subject to a landlord saying, you know what, I'm going to raise your rent at a certain time. And the act that Sam's referring to, the Landlord-Tenant Act, gives the precise way of doing that. Notice has to be given, that the period of time is covered, that if you can be a week-to-week tenant, month-to-month, it's how often you pay your rent. Whatever it is, you have to give the required notice as the landlord, and then the rent goes up. And without a lease, the tenant is really subject to that raise in rent as long as the landlord follows the rules.
And I know we say that we often provide resources for people if they care to do it themselves. Maybe they need you, maybe they don't, but in either case, the nolo.com and findlaw.com are two common resources that people can use to, say, refer to what's going on in the state of Maine versus Rhode Island if they should be in that situation where they need to do some sort of a residential lease. So that's a good resource.
And there is a Rhode Island Landlord-Tenant Handbook that's available online too for people to refer to.
Would that be at the state government state.gov?
It is put out, and if you Google Rhode Island Landlord Tenant Handbook, it should be one of the first results.
So logically, that might be true also if you had Massachusetts landlord and tenant laws
it
and
may be.
regulations.
And it would be a good idea for both a tenant and a landlord to have that information because, as Sam said, there are certain things that you can contract for in your lease, but there are certain rights that you can't contract away, and both the landlord and tenant should know what those are.
Okay, so you decide on a certain rent, you agree on that or whatever it is, and something goes wrong with the house or the apartment. Who has to fix what? What's the landlord responsible for? Leaky faucet versus the ceiling falls down or something. Who's responsible for what?
Usually that's going to be specified in the lease, who is responsible for what.
Yeah, and if it's not in the lease, under the Landlord-Tenant Act?
You would have to refer to Landlord-Tenant Act to see exactly, depending on what the actual problem is.
Right, and certain things in the Landlord-Tenant Act that become such that it interferes with the tenant's ability to live in the apartment.
Habitable.
Yeah, so if it becomes uninhabitable, the heat doesn't work any longer, and it's the middle of the winter or something. There are certain rules that apply to the landlord that if they don't fix it, the tenant can take some action in terms of withholding rent or things of that nature.
That's what I was going to say. So follow up on that. Would it be a reasonable thing to say, you didn't fix my heat, I'm withholding rent or a portion of the rent, or I'm going to have it fixed myself and I'll deduct it? Does the tenant have a right to do that?
Put it in writing to the landlord. Anything that you're going to do, put it in writing to the landlord. Make sure you have documentation of what the alleged problem with the apartment is and your communication between yourself and the landlord if you're the tenant, communicating to them exactly what it is that you think the problem is and what you've done to take steps to fix it.
And we always say this, put things in writing. We're always constantly saying that's a very important thing to do. In this particular instance, it's really important because the certain rights get put in place once you do that. For example, if you don't notify the landlord that there's a problem for them to fix it, the landlord can say, I never knew about that and you didn't have a right to do this, that, or the other thing. So if you don't pay to fix something but you want to withhold rent and you have to give the notice, let them know why, give them a chance to cure the problem. And also, I think Sam would tell us that you want to put the money aside in an account so that it's available once the remedy is put in place for the court to decide if it does end up in court what you need to pay. And I think you have to let the court know that I set the money aside in a separate account in many instances.
So we're here to give some tips. This is a good one. Would you recommend, even if they haven't contacted a lawyer about something such as this, would it make sense, I'm going to put a CC and send a copy to my lawyer just in case? Maybe it helps that landlord know that you are very serious, that they really should fix that heat or that plumbing issue. Does that make sense?
If there's a lawyer you have a relationship with regard to either your issues as a tenant or a landlord, it does make sense to put them as a CC on the letter.
And before you send the letter, I would contact your lawyer, let them know the problem, make sure you're taking the correct steps. If you don't have a lawyer and you don't want to contact a lawyer, at least refer to the handbook or your lease and see what the rights and rules are that you have to follow.
So when it comes to something as trivial as, and I have heard this, my light bulb, or it needs to be changed. So reason would say, change it yourself. Do you really think that you should be deducting the cost of the light bulb? Is that really worthwhile that someone should even ask for such? Seems so silly and trifling.
No. Yeah, there are certain things that normal wear and tear, light bulbs, things like that, that unless it's specified in the lease that the landlord has to come in and change your light bulbs, I would say that probably falls on the tenant's responsibility.
And to take that just a serious step further, what about when the tenant decides that they didn't like that retaining wall and they wanted to put a door in another place? It would seem that any lease would say that no structural changes should be made, but how should that go, and how different is that from, I think I want to change the paint?
Yeah, so most leases will have language in them that says that you can't do any construction or change anything to the property without the consent of the landlord. Paint, probably, as you say, a different issue, but again, it may be in the lease, it may not be, and so that's sort of on a fine line as to whether or not the tenant has the right to do that or not do that. It would depend on the language of the lease, or if it's month to month, refer to that handbook.
Okay. What do you consider a reasonable thing for the landlord to do if that wasn't observed, whether it was or wasn't listed in writing somewhere in a lease? Doesn't it make sense that someone wouldn't even want to pay to take down a wall, even if they were a handyman or woman? What's the recourse that the landlord has when they suddenly find out, having not been asked, and now there's not a retaining wall, a different door, a different lock? What should the landlord do?
Well, this brings us probably to security deposits. Most landlords will take a security deposit when a tenant begins their tenancy at the property, and the procedure for the security deposit is that as soon as the tenant moves out and the landlord discovers the problem, they should document it. They should put a letter, again in writing, to the tenant. They should identify what the issue is that they have that they're going to deduct from the security deposit, and they should provide any itemized costs they have with remedying the issue that the tenant has left.
So something such as this probably doesn't take place in a week. Maybe it does. But how often should a landlord visit the residence, if that's the case, just to make sure that everything is as it should be? What's reasonable?
Well, there's no need to unless there's some suspicion to. But if they are going to do it, once again, there should be notice provided to the tenant.
What kind of notice?
I would recommend at least 48 hours notice to the tenant, unless there's some emergency circumstance.
Sam, would that be in writing, or just would a phone call help be sufficient?
A phone call would be sufficient for a visit to the property, I would say.
Yeah, but if you're not on solid ground with your tenant and you want to make sure there's some protection and you have email address, it's always good to do something by email so that there's a record of it.
Okay. And say, for example, someone had a lease for a year. This is a specific question that was asked. Someone's had a lease and it didn't have a finite date of being 1 year or 2 or 3 or 5, and 14 years pass. 2 people are living in the house happily and taking care of it. On an occasion might say, we painted the house, we painted the wall. And then something happens that means that we need to get involved and take a look at, the landlord has to go take a look at it. If there's a domestic situation, a man and a woman, usually you'd think that they would take care of it, but the landlord is responsible for the property. Something starts happening to the property that brings the sheriff there. What happens now? Does this suddenly become a lawyer's issue?
Well,
how does this play out?
How about some more specific facts?
So a man and a woman have a lease. They're not married, doesn't matter. But suddenly someone new ends up on the scene. Let's call her the interloper, for lack of a better. And now the 2 tenants, the husband and wife, not really husband and wife, are beginning to have some trouble, and there's alleged harassment on both sides. And a restraining order, woman against man against woman against the other woman for harassment. And so this goes, and it brings in sheriffs to the door. And then the landlord, of course, needs to be involved because the sheriff has contacted the landlord.
What does the sheriff want the landlord to do?
That was the first question. So you need to know that someone put a new deadbolt on your property, and it was a deadbolt that locks someone inside the property. I'm not sure I could fully understand how this happens or why one would do this, but that means, says the sheriff, that that is a safety issue, and the landlord must take care of that immediately.
Yeah, and I would agree the landlord would have to remove something that creates a safety risk to the property. But you're also now getting into another situation with the tenants, the landlord, and whether or not it's a situation where you need to consider as a landlord whether someone needs to be evicted. What I don't like to see happen, and Sam and I have some experience with this, is where the landlord gets involved in a divorce or domestic situation between husband and wife, and now all of a sudden wants to take an active role in determining who's going to get to stay and who isn't. The landlord shouldn't try to usurp the power of the family court, where the family court can say husband can stay, wife can stay, both can stay, whatever, as opposed to the landlord coming in and saying, I'm going to evict the wife because I like the husband better. And then the question becomes, does the landlord even have the right to do that, since actually The husband is the tenant. The wife lives there because she's married to the husband. And what right does the landlord have to evict the wife who's not a tenant? And if the husband wanted, and he's doing it for the husband, and the husband's already tried to get the wife put out because he's getting divorced, and the family court judge says, no, there's no grounds for you to do that. It becomes a very interesting situation.
Good point. And if the landlord certainly doesn't want any part of the
Domestic
situation, but it does prompt the landlord to suddenly be on the premises because they need to know what's going on in their property, considering a sheriff's been there and the new woman who invades or is asked to stay suddenly ends up having caused enough harassment that she is taken out in handcuffs, and the landlord is notified of this. Well, that means the landlord is now on site. And only now on site does the landlord find out that there were substantive changes made in the home. For example, the retaining wall, a change in where the door is placed, a new set of locks. How about a pellet stove in a barn that's 200 years old? I have no idea. We've not heard whether or not this person had a permit even. What does that landlord do with this? Evict?
Did the tenant put the pellet stove in?
Yes,
yeah.
And apparently the landlord knew nothing of this.
Okay.
Including whether or not there was a permit pulled, if they needed one.
So, at the beginning of the hypothetical, the lease was a year-to-year lease?
Was just an open lease, as I understand it?
So let's just say it was a lease, even if it was a lease for a specific period of time, but that's just sort of gone on and on and on. And they pay monthly. It almost becomes a month-to-month tenancy at that point in time, unless the lease had automatic renewal language that it renews for a year at a time. So you'd have to look at the specific terms of the lease.
That's a good point.
But if it's now just being done month-to-month, then you have to look at, of course it's Maine, but if it were Mass or Rhode Island, whatever the rules of that state are, landlord-tenant, and it might be time to evict all of those people out of that property. And the lease or the tenancy was with what we're going to euphemistically call the husband and wife, or the first woman who was with the man in the property.
Yes.
And if the lease is specifically with them, I would say you have to do an eviction with both of them. Of course, if there's a third person in there who the original wife didn't want in there, she should be filing something herself under the Domestic Violence Act, if there was violence, because you talked about handcuffs and sheriffs and all of that, or a restraining order in whatever court is appropriate in Maine and Rhode Island. If they're not related, it might be Superior Court, to have her put that other person out. But the landlord's relationship is with the first two people, the tenants, and whether it's month to month and they're paying their rent and you want to be specific, you would send notice to terminate the tenancy, tell them they have to move out by a specific date, whatever the rules are in Maine. In Rhode Island, you have to give enough notice, at least the term of the tenancy, a month. And then if they don't move out, file the eviction.
And let's talk about evictions. So if someone has lived in a home for longer than a year, or like 14 or 15 years, they've certainly accumulated a lot of things. What's reasonable? What is the eviction process? Is that something that someone can do on their own? Do they really need a lawyer? How do they go about doing that?
Well, the time frame for the eviction does not depend on how long the person's been living there. It depends on the terms of the lease. So if it's a month-to-month lease, like David said, the landlord would have to send a termination, a tenancy letter, giving at least the 30 days, and it would have to comply with the Rhode Island statute. Or if they haven't paid their rent, it's a totally different process for that situation. That would be a 5-day demand letter demanding that they pay all the past due rent, or else an eviction could be filed as soon as the 6th day after the letter.
And you say 30 days. I've read in doing some of this research that it actually takes quite a long time to have someone evicted. Is that true? What are your findings?
For something other than non-payment.
Yeah, well, after those 30 days, if the tenant remains, then an eviction has to be filed for reasons other than non-payment, which allows a 20-day answer period for the tenant to file an answer as to why they think that the landlord does not have grounds for the eviction. If an answer is filed at that point, the case would then have to be set down for trial. And the trial date would depend on the court's calendar. So depending on which district in Rhode Island you're in, it might be a different time frame, but it can be up to a few months to get the trial date on a contested 20-day answer eviction.
Apparently, I think it's the state of Massachusetts, I only had read of it in one case on the Cape in Massachusetts, that the judge had determined that no one was going to be evicted for a while because it was in the middle of winter time, and that might cause some undue harm or whatever to the tenant at the time. Do you hear of such?
Those things come up, yeah. It depends on the facts of the case.
Sure.
And what judge you have and what is going on in the situation. So if it's a non-payment, I don't think that would be something a judge would do, but if it's for something other than non-payment, perhaps they would extend the period of time before the eviction actually happens.
So let's go back to if someone has made those structural changes, permit or not permit, is that alone a reason to ask to have someone removed from the house?
So if there's a lease, again, I would look at the lease first, but certainly if someone's done something to injure the property, that in and of itself can be a claim. Again, the safest way to do it is to terminate the tenancy and go through that route. It's usually, to me, and you can disagree if you want, but it's more difficult to, let's say there's a lease in place, evict somebody for violating the terms of the lease as opposed to terminating it. And what I mean by that is, if there's a lease in place, well, it's difficult to, you do have to do it for violating the terms of the lease. If the lease says you can't change this construction, you have to send notice, you violated it, they have the right to cure usually under the lease for a period of time. If they've moved, and done construction and moved retaining walls and things like that, it's going to be difficult to undo that. So it can be done. If it violates the lease, a judge can throw somebody out for violating the terms of a lease, but it becomes difficult. Oftentimes, one of the examples is if it's more than a one-family house and there's a noise limit in there and they keep violating the noise rules in the lease, you send notice, then you're going to end up with a trial where you need to bring evidence of the other tenants in to say, oh yeah, 2 o'clock in the morning there's noise and it's constantly bothering everybody. Those are more difficult cases for a judge. But absolutely, if there's no lease in place and it's a month-to-month, I'd say terminate the tenancy and evict them that way.
And some people say when you write up a lease, you specify no smoking, no pets, whatever. If it's not stated and you suddenly see that someone after a year, 3 years, 15 years, 20 years, gee, they've obviously been smoking or they've had people here so that it is so noticeable, would those be grounds for eviction?
Go ahead, Richard.
It could be, depending on the damage that's being done to the property. Or it can be an issue like David suggested before that may prompt the landlord to send a letter terminating the tenancy so they can move on and find a tenant who they feel is more appropriate for their property.
Here's an interesting situation I had once where the lease, and there was a lease in place, clearly said there is no smoking in the building. There's land, you can go off the land, building and smoke somewhere else. And now the issue became, what about the person who was in there with the medical marijuana card? Can they smoke marijuana in there because they have the card? And the determination in that case was made that the reason there's no smoking in the house, smoking a cigarette is just as legal as smoking medical marijuana. But the reason is because of the damage it can do to the property, stain the walls and all of that thing. So eventually, to avoid eviction, the tenant agreed in that case, I can smoke my marijuana, but I have to also smoke that outside. So, and that was something that actually was negotiated after an eviction was filed in court. Don't know what the judge would have done on that, but it's an interesting situation.
It's a good scenario to bring up. So you are a landlord of a residential building, and you find that I think the word was, the tenant decided that they wanted to have a little side business. impact? Is that worthy of eviction? How does that change for the landlord or even the tenants in terms of how the property is insured and what kind of impact it might have because a business is run from that residence?
I would say it depends if it violates the lease, and it depends if it violates any of the zoning ordinances for the town.
Yep, that's exactly right. Certain businesses can be run out of a house according to the zoning in certain cities or towns. Others you can't. Certainly, like a retail business usually cannot be run out of a residential zoned area. An in-home office can be allowed as long as there's not a lot of disruption to the neighbors. A lease is usually the best way to control what can and cannot be done, and that should be something that is in a lease.
Okay, and another question was, if someone is renting a house or an apartment and they decide that the tenant is going away for a month to have a vacation someplace, are they allowed to sublet it? Or if they wanted to be part of a little Airbnb that's become very popular, who gets to decide that, and does the landlord need to be notified? How does that work?
Again, it should be, in most leases, it will specify whether or not the tenant can sublease the property while they're out. So it would be negotiated ideally before the tenancy begins.
And it's probably not a bad idea for a landlord to take a look at their lease and decide. There's almost always language in a lease about assigning or subletting a property. Probably not the Airbnb situation. Probably a good idea to go back and take a look at that, and as you're moving forward with new leases, decide what kind of language you want to put in on that front.
So if someone had a lease and if it didn't say that it was the ending on a certain date, when do you get to revise that lease? Or do you?
Well, one of the things that you should put in a lease is the term of the lease and how it's renewed and when it's renewed and what you have to do to renew it. I would argue that the terms of the lease may roll over month to month if there's no ending date, but that it's only a month-to-month tenancy at that point if you pay monthly.
And for those who are commercial, landlords of commercial properties, do the same things apply, same issues apply if you, I assume, would have to have a lease in place then? Same issues apply if that person wants to knock out walls, put in new structures? Same issues?
So, commercial landlord situation, very different from residential. That landlord-tenant handbook doesn't apply. The rules at common law and by statute are different. It's always, always, always important to have a lease in those situations, and those leases can be many, many pages as opposed to a few pages that you might be able to do a residential landlord-tenant lease for, and all of those issues are usually covered in a lease. Oftentimes, a landlord and a tenant will enter into an agreement about what the scope of the work the tenant will do and what the landlord will do when they move into a commercial situation where they're changing the use of it from retail store to restaurant or something like that.
Good to know. We've certainly touched on quite a few issues. We hope that this has been helpful to you. We hope that the resources nolo.com and findlaw.com have been helpful to you. And if you need a lawyer, certainly we hope that this has been helpful to you. Stay tuned to The Law Matters because, of course, the law matters to you.